What are grandparents' rights in New York? Grandparents in New York may petition family court for visitation and, in limited cases, custody. These rights are not automatic, and the court applies different legal standards depending on the relief requested. For visitation, the first issue is standing, which means the grandparent must show a legal basis to bring the case. If standing is established, the court then decides whether visitation would serve the child's best interests. A fit parent's decision to limit contact receives substantial weight because parents have a constitutional right to direct a child's upbringing. That means a grandparent must show that continued involvement would benefit the child. The U.S. Supreme Court's decision in Troxel v. Granville reinforced the rule that courts must give special weight to a fit parent's objection. In New York, grandparents have automatic standing to seek visitation when one or both parents are deceased. When parents are divorced or separated, a grandparent may still petition, but the court will examine whether equitable circumstances justify intervention. If both parents are alive and united in opposing visitation, the grandparent must satisfy that equitable circumstances test before the case can move forward. Courts look at the nature of the relationship, efforts to maintain contact, any parental interference, and the reasons for the parent's objection. A documented history of school involvement, childcare, or consistent communication can strengthen that showing. In intact families with two fit parents living together, courts apply especially careful scrutiny before permitting a visitation claim to proceed. Once the case reaches the best interest stage, the judge reviews the totality of the circumstances. Relevant factors may include the depth of the bond, the grandparent's willingness to support the parent-child relationship, and the possible emotional effect on the child. An older child's preferences may also matter if the child can express meaningful views. The court may appoint an attorney for the child when the judge decides that doing so would serve the purposes of the Family Court Act. Custody is different from visitation and requires a much higher threshold. A grandparent seeking custody must first prove extraordinary circumstances before the court will consider best interests. Extraordinary circumstances can include abandonment, persistent neglect, parental unfitness, or an extended disruption of custody. An extended disruption of custody may exist when the child has lived with the grandparent for a significant period, typically 24 months or more, without a consistent parental relationship. When a child faces immediate danger from abuse, neglect, or another serious threat, grandparents may seek emergency custody. Grandparents seeking visitation in Manhattan must file in New York County Family Court at 60 Lafayette Street. Strong documentation can help, including photographs, records of visits, letters, school or medical records, and witness affidavits. After filing, the petitioner must properly serve notice on the parents or legal guardians, and the court will schedule an initial hearing. Mediation may also help families reach an arrangement, and courts often view cooperation favorably. A lawyer can help prepare the petition, organize evidence, and present a clear argument in family court. An attorney can also advise whether the facts support visitation, emergency relief, or a custody petition, and the law firm can guide families through each stage of the process. For help from the law office of Richard Roman Shum, Esq. Call 646-259-3416 or visit 20 Clinton Street, FRNT 5D, New York, New York, 10002, United States.